session. It's going to be on transparency in the patent process. Yvette Liebesman is the moderator. She's an assistant professor of law at St. Louis University, where she teaches and writes on a number of intellectual property issues. She has a whole string of degrees. She has a BA and a BA from Georgetown and her law degree from Georgetown. She also has a BS in physics from Rutgers, and she has an MS, a master's in oceanography, of all things, from University of California, San Diego, the Scripps Institute. Very accomplished writer. She just recently won the Lattice Award for Trademark Scholarship given by the International Trademark Association on her recent piece called "The Mark of a Resold Good." We're really honored to have her here today, and I'm going to let her introduce our last two panel members.
Okay, so we are what's separating you from drinks. But we'll hope to make this entertaining enough that you'll say, drinks? We don't need drinks. We have these wonderful panelists. So yes, we are talking about transparency, and let me give you a situation. Imagine you hear about a patent infringement suit where the technology is similar to yours, and this is what's being litigated. So you log onto Pacer, or you go down to the courthouse to get the filings and the orders and the motions to figure out whether or not you have to do a workaround or something. And then you go and you find out all these key parts of the record are under seal. And this is actually happening quite a bit. For example, there was the recent Monsanto versus DuPont suit, which resulted in a $1 billion verdict. That's billion with a B, in favor of Monsanto. And most of the key records for that are under seal. There were about 1,700 Pacer entries. Almost 600 of those were under seal. 183 of these were summary judgments. 140 had to do with discovery. So basically, how can you figure out if your invention is infringing? You can't possibly devise a workaround if you don't know what you have to work around. So that's one issue that involves transparency. But this lack of transparency also is going to lead to an absence of ownership information available to the public. When you don't have the transparency, you don't even know who owns the patents for which you need to seek a license if necessary. Third, this can also play into patent applications. Innovation is going to be hidden now with ambiguous claims and patent specifications because everything's under seal when you're actually doing a Markman hearing and trying to figure out what these things mean later on. And then finally, you can probably see how all this new secrecy in patent litigation can actually interplay with trade secret law. So we have Bernard Chao and Dennis Crouch, the three of us along with all of you are going to be having a conversation about these ideas. Now, Bernard is an assistant professor of law at University of Denver's Sturm College of Law, and he writes and teaches about IP issues. He received his BSEE from Purdue, his JD from Duke, practiced for 20 years in Silicon Valley, and he remains a counsel at the firm that he founded there. And in addition to being a professor, if that's not busy enough, he's also currently the special master for the largest group of patent litigation cases in the U.S. in Inri Katz Interactive Call Processing Plant litigation. And then we have Dennis, who is our wonderful host, one of our wonderful hosts today, and he's an associate professor of law right here at Mizzou. Prior to joining the faculty, he was a patent attorney at McDonald, Bain & Hulbert Berghoff in Chicago. Did I say that right?
Yep, except
okay.
the and. There's an and.
Oh, the and.
LLP.
LLP, okay. In Chicago, thank you. And he taught at Boston University Law School before coming here. Dennis received his BSc in Mechanical Engineering cum laude from Princeton, his JD cum laude from the University of Chicago Law School, and as we all know, he's the founder and editor of Patentlio, which is regularly voted the #1 IP blog in the US. So we're going to start with Bernard. He's going to give us a few thoughts, and then Dennis is going to give us a few thoughts, and then we're going to have some questions both from me and hopefully from all of you, and we can have a nice conversation.
Yeah, so I thought I'm not going to give you everything that I've written about in this particular field. I'll just sort of give you the story of how this all happened. It's not like transparency has been the field of study as a patent litigator that's most interested in. But what's happened is initially, so I practiced in Silicon Valley for many years, and so as a professor for the last 4 years, I've started to write in the area of technology and patent law, and I have a number of former colleagues and friends that are in-house at semiconductor companies. And one of the interesting things I was thinking was, gee, to infringe, you have to make, use, and sell something. Every company that I represented actually never made any semiconductors in the United States. They didn't sell any semiconductors in the United States. In fact, they didn't even import them because it was all done abroad and other people imported. So the thesis of the paper I was about to write was what the strange immunity of semiconductors from companies from patent litigation. So I called them up and said, it must be that you never get sued, right? And he goes, no, we get sued all the time. What are you talking about? You're totally wrong. They said, well, what happens is we actually are sued for using our the accused technology in our laboratories because we developed the technology in the United States. I said, well, really? I've never seen this in an actual case. They said, well, we usually settle, so. But here are 5 cases. Literally, I talked to 3 or 4 different in-house counsel. Here are 5 cases you can go look at, and you'll see, we found out, because we think this is full of it, we disagree with this theory, that there should be no damages from the use of a testing product. Our Dalbert motions are on file, our summary judgments are on file. I went, and I couldn't find a single one. 0. I got the PACER filings of some of the biggest cases in patent law. One of them that I think was talked about earlier, Broadcom v. Qualcomm, was one of the cases I went to. You cannot find out what the allegations of infringement actually are. The complaint says make, use, or sell, but after that, you don't actually find out what predicate activity is. And so I could never verify this theory, so I've never written this paper. So instead, what I did is I wrote a very short piece in Patent Law a few years ago, and this is how it all sort of started, which basically said, let's see how big this problem is. And I said, well, I'm not really serious about this. I'm just going to have some RA go look at 3 cases in each of these most litigated patent districts in the country to see what's going on. Turns out, I think it was like 5 out of 8 of those, I couldn't see the filings of summary judgments or the like. They're totally under seal. And then so then Dennis asked me to keep looking at this for this particular conference. So I wrote a piece that goes with the Monsanto case. Well, I've learned more. So more things. So not only are the key filings under seal, actually orders in many of these cases ruling on summary judgment motions are under seal. In the Monsanto case, for example, exhibit lists and objections to exhibit lists are under seal. There are motions like the motion for the order of witnesses is under seal. The ruling on that is under seal. So we have situations, and it's everywhere. So now the press actually call me to actually get a comment about, hey, is this really under seal, or what's the case? What's the situation? And usually what I do is I go, well, let me check on PACER, yeah, and I go, yes, it's under seal. And I say, hey, I will get you free attorneys to intervene in this case so that so we can unseal this, because this is wrong. They all say, no, I can't, I got to talk to my general counsel, it's going to be really a problem. So the only case that we've actually had the press intervene in is actually the Apple-Samsung case. So that's the only case I'm aware of. And even with free counsel volunteered by me, we've been unsuccessful. I've had one situation where the reporter said, well, so one of the, let me say, I want to say that this is actually unintentional, I think. That it's not that, unintentional by the courts, I should say. So I don't think that the courts are, we should grant all these applications sealed. You get a motion to seal, and it's typically unopposed, right? Because both sides get to see everything. And the court says, I got a consented motion from the parties. Where do I sign, right? I mean, this is great. How often do I get this? So we get this situation. So I've told the press consistently, I don't think this is an intentional, at least intentional by the court, a problem. I think the parties are having a little bit of a sort of being overly cautious. But so one of the reporters actually called, took my advice, and said, I think that this isn't really intentional. He said, well, let's test it. So he called a judge in Wisconsin. Actually got the judge on the phone. And I learned, at least this is secondhand, but what he told me is, so I called the judge on the phone, told him, did you know you sealed all these orders and these motions? And the judge said, no, I didn't know that. He goes, really? And he goes, really? And the judge goes, well, all right, we won't do it. And that was how easy it was to actually change the policy in one court. for a very high-profile tech case. And I don't think that this view is, I don't think that this is a solitary view. I think that what we're seeing is a consistent problem that is pervasive, but isn't totally intentional. I will say it's hard to take care of this because, so I've also talked to clerks and read some opinions discussing how difficult administratively it is to deal with these applications to seal. There's a lot of effort by the courts to review documents and try to make sort of a parsing, oh, line 15, no, I don't want to give it to them. And so it's, there's a lot of effort behind it. But I do think that there are at least some solutions. One is to at least signify that, for courts to signify that they do take it somewhat seriously, that they use some degree of caution.
So what you're saying is that if they find that it's proper to seal something that's obviously secret, that the easiest thing to do administratively for the courts, because they're understaffed, is just to seal everything, because it is too difficult to go and for each item to figure out whether it's deserving of the status.
So yes, the answer is it is very easy for a court to just approve all and not give any scrutiny, right? That's a very easy solution. And so the result is you get almost everything under seal in some of these cases.
Especially when both parties consent.
Yeah, I think that's right. So one solution that I propose, just so you know, is that any sealing that there be a public version. It's actually the Federal Circuit rule for appeals that when you file a brief, you can't seal an entire brief. You have to file a public redacted version. That's, I think, a fairly easy fix that will not take care of the problem by any stretch of the imagination, but will take care of the worst of the problem. Like we'll get a gist of what's going on as opposed to nothing, right? And so that's something that I've suggested that we do. But let me sort of end it there. I have a lot more that we can discuss, but I could.
Okay, yeah, and so taking Bernard's lead, I'm also talking about and writing about this topic of transparency, but taking it outside of the courts and thinking about what's going on in the patent office and other administrative agencies in terms of secrecy of information. And I liked what Kevin Noonan, my former boss, said earlier this morning, although in a slightly different context. He's like, a lot of us see patents as these, or think of patents as these unseen celestial bodies that you can only detect by their impact on the world, right? We can't really see them and detect them very easily, and I think there's a lot of truth to that. But right, Kevin was a bit, in a sense, you could see self-contradictory because he also talked about how there's this, how the point of patents is the disclosure. And then, right, but if they're unseen, well, then that seems, right, that there appears to be a potential problem. And there's kind of three main topics that I work through in my paper, and we can talk about more today as well. And one of them is an absence of ownership information. And our keynote speaker, Greg Gorder, today talked about how when they look at patents, they think about owners. Right, and if you're someone who's a manufacturer and you see that your supplier has certain patents, you might think about them differently than if they're owned by intellectual ventures, because you know your supplier won't come after you, and you can rest assured that intellectual ventures will come after you. And so you think about them differently in that standpoint, and there's just a reality that if you search on the Patent Office website or other databases of patent information, if you look up pending but published patent applications, the vast majority of those have no assignee listed, even though the vast majority of those are actually owned by some company that is pursuing that information. Now, by the time of issuance, there tends to be an assignee listed, but just the current state of affairs is that if, for whatever reason, you would not like your ownership to be well known, it's a simple process to create a shell corporation that owns your patents and not publicly identify that you are the owner of the shell corporation. Now, right, so that's kind of the setup, that it's hard to know who owns what in many, many cases. But there's an obvious policy question, well, is that actually a problem? And right, if I go to if I go to some store or go shopping on Amazon.com and buy something on Amazon.com, the fact that I own that product that I bought, I don't think there's any need to have that be public information. Right, the fact that I own a vest. Everybody doesn't need to know that if I keep it in my own If I keep it in my own home and don't show it publicly.
Just the NSA.
Right. The NSA may. We do have this. Right. We do have this issue, but and the Supreme Court has ruled on kind of different issues. Right. Not this exact issue of ownership of property rights, but the Supreme Court has a history of supporting both privacy interests and rights of anonymity as constitutional rights. And for certain privacy interests, Congress has stepped in, both state and federal legislatures, in promoting this right of privacy. If you think about real property, though, when you buy a house, there is a usual process of recording your interest in that home, although for the most part, there is not a law that requires you to record your interest. But instead, there's some strong incentives for you to do that, so that no one can fraudulently claim ownership at a later time. Now, of course, one big reason why the government also wants you to record your property interest is so that they know you own this, so that they can tax you. And that is just kind of an example of the reality that when government has information or when others have information about you, the tendency is they'll use it against you. So it makes sense that if someone has something has patent ownership information, that they would want to keep it secret until the point when it benefits them to make it public. And so we have this issue, and with patents, at least I think that patents are different from the vests that I buy online, in that there's not really a public interest in knowing what I've purchased from Amazon, but there is a public interest in knowing who owns what patents, because patents are this intellectual property form that tells everyone in this country what they can and can't do with their physical things. Right? If you have a device and someone has a patent on a certain use of that device, well, you can't use your device for that purpose. Right? The patentee has that exclusive right, and so because of that real conflict that we've heard about throughout this day, that real potential conflict means that for anyone who wants to not be violating the rights of others and who wants to protect themselves against potential lawsuits needs to know that type of ownership information so they can get a license or else avoid infringement. And so that's a basic problem. Now the reality is there are works in progress, and we may talk about that later. There's both legislation and actions at the Patent Office and at the FTC to move forward either administratively or via statute to essentially requiring substantially more ownership information, and so placing more burden on patent owners to spell out exactly who owns this. And we may end up talking about that. A second point that I wanted to talk about a little bit is this importance of trade secret information and its interplay with patents. And in a big way, the only way that you can protect a trade secret is by taking reasonable precautions to keep your information secret. And in some ways that seems completely opposite to patent law, because the only way you get a patent is if you publicly disclose this information. And so it would seem that the things you patent cannot also be protected by trade secret. And it turns out, though, that there's an increasing sophistication amongst technology developers, including their patent attorneys and others, in developing strategies to protect their innovation, the same innovation, both through trade secret and through patents in a simultaneous often definitely successive, but also simultaneous form. And unlike when we may get into this with Bernard, but in litigation, the trade secrets that we're typically talking about are trade secrets that are developed kind of after the patent issues. So information, but that are still kind of secret information, maybe about what the infringer's doing and their sales and all sorts of information there. Whereas with patents, we may be thinking about particular trade secrets, such as the actual code that you use to develop your software that folks typically don't put in patent applications, or particular embodiments that you might not actually disclose. And one thing that's happened, one potential problem with the America Invents Act, although even before the America Invents Act, there was already a very strong incentive for innovators to file their patent application at a very early stage. And so as soon as you have an idea that you have conceived of, that you can at least tell someone how to make and use it, that is satisfy the disclosure requirements of patent law, the best practice that any patent attorney would tell you is at that point you should go ahead and quickly file your patent application, because the earlier you get it on file, the more likely that your rights will be valuable rights. But one thing that happens with any technology development is that after that initial conception, there is a substantial amount of post-filing activity, and where you're actually building an actual working product, or working on the development process for producing this chemical that you're claiming, et cetera, and typically come up with lots of other small innovations that might not themselves deserve patent protection, and instead those are kept secret. And so there tends to be, with any manufacturer, lots of trade secrets surrounding the periphery of their patent portfolio that they've developed either before or after patenting. And what's the problem with that? Well, the only problem then is essentially whether that's satisfying this quid pro quo that we think of disclosure, this requirement of disclosure as what the innovator gives up in return for having an exclusive right over the broad innovation. And so that's a policy question that I think hasn't been developed because there has not been any kind of wide understanding of this real and ongoing interplay of how trade secrets continue to be used as part of the patenting process, and is not, that there's in reality less tension than many of us would have thought of based upon reading old Supreme Court cases. Now, my third element of transparency comes out not through actually hiding information under lock and key, but instead hiding things in plain view. And I think Greg Gorder also revealed this as he was speaking, that it's really hard to read a patent. It's difficult to read a patent, and it's confusing to read a patent. And the way that patents are interpreted means that they are typically ambiguous, and many folks will, many patent attorneys have the preference of reserving any judgment on a patent until it's been decided, until the case has been examined by the Court of Appeals for the Federal Circuit, which is kind of years down the line and problematic if we want any kind of market for patents available. And these days there is just a strong incentive for patent applicants to not particularly disclose what their incremental invention is. Because when you do that, it comes back to haunt you later in litigation, because you're essentially setting a target for yourself that makes it easy for someone to go after. And so essentially no patents that have been drafted by a professional today say our particular incremental innovation is X. People just don't do that. That's not the practice because it leads to problems. In addition, there are lots of incentives to draft patent claims that are ambiguous and that are unclear in terms of their scope. And one nice thing for patent owners is that you can have as many patent claims as you want in a single patent, and so you might choose to have some small subset that have a very clear scope, that you think are strong and defensible, but then you could still add another 20 additional claims that are much more ambiguous and otherwise hard to explain and understand the boundaries of, but you get those anyway as insurance and essentially as the new form of doctrine of equivalence, where once you get into claim construction, you can argue for a broad construction. That practice has the obvious implication of making it really difficult for third parties to understand where the patent rights start and where they stop, and whether your invention is valid or invalid. And because of that, in my view, that's the largest problem that we have in patent law today. This real ambiguity that is available in every patent that you see. And if that were ended, right? If these were not so ambiguous, I think that Mr. Gorder's goal of having a true market for patents would be much easier to realize. So that's the third part of my paper. Now, as an aside, before I go further, we've had some talk throughout perhaps each session a little bit about arbitration, and arbitration is an interesting issue in the patent field, in that we really didn't have it before 1982 because the courts thought that it wasn't enforceable, and many arbitration decisions over the validity ended up not necessarily having res judicata effect. We have this statute, 35 U.S.C. 294, that says that first of all says that arbitrations are enforceable. There's also an interesting transparency provision in that statute that said, I jotted this down, it says, quote, when an award is made by an arbitrator, the patentee shall give notice of the award to the patent office. Okay, so there's a requirement that if there's an award, you have to give notice to the patent office. And so off the bat, this makes, many of us, when we think about dispute resolution and arbitration, we think about one potential benefit is its secrecy. And so this takes that largely out of the secrecy realm. However, one thing that I found, earlier this year, I submitted a Freedom of Information Act request to the Patent Office asking for all of the arbitration awards that have been submitted to the Patent Office, and the result, what they gave me, is that at least they could not find any. And this conflicts, This conflicts with the folks at the American Arbitration Association and other arbitration groups who say, yes, in fact, we are doing patent arbitrations, and they're just not. The transparency element of that is just not coming through as the law requires. So I think I'll stop there.
Okay.
And
so first, let's questions from the audience. George?
Just to make a comment on Dennis's very last point, I think a lot of the stats that AAA and WIPO give about patent arbitrations in the U.S. are royalty disputes as opposed to validity and infringement disputes, which are the ones that are required by the Act to be filed. And it's very confusing when you look at the popular press and so forth. There are articles that say, look at all these patent disputes being arbitrated. They're almost all royalty disputes as opposed to the other one.
Well, at least my reading of the statute would be that if the royalty depends on the scope of the claims, then the statute, at least the way that I would read it, would require submission of because that is the equivalent of We're looking to see whether whether they fall within the scope of those claims.
You may have a more generous reading of the statute.
Okay, than the people who were and that's the problem. That's the same problem is the burden we're putting on folks to submit this secret information. We're putting this burden on them perhaps, but there's no checks.
Yeah, because there's an article on IP Watchdog from just a few months ago that has a list of it.
What's that? I haven't heard of that site before. I know. Which again is very, I think, very misleading. Okay.
Other questions?
I have a question on the point Dennis made about patents being difficult to read and ambiguous. And what if any ideas you have on fixing that? I mean, do we need to change the statutory requirements that written description or encourage judges to start invalidating patents on one file first and second? I mean, how do you know, because there's definitely reasons why an attorney, when drafting, wants that type of ambiguity. So later on, when there's, developments that they can't account for, they're still covered.
I mean, I can tell, as a customer, the answer I get is malpractice. They're afraid that they, by not being very broad in their language and not being able to capture something that in 5 years later looks like, wow, that really should have been in there. So the kitchen sink are
Well, and even, within 2 years, you can have broadening reissues, and you can go to your client who's developed this thing and said, okay, this is now how it is. Oh, wait a second, I didn't cover that embodiment. You got to give me more money so we can go back and get this covered in the patent office.
What can we do about this? And we could take a step back and say, well, first of all, we can recognize that the Supreme Court, at least in their jurisprudence over the doctrine of equivalence, has noted, well, ambiguity, we should allow some amount of ambiguity so that people can actually get a patent that covers their invention without necessarily hiring the very best patent counsel in the country, right? They can just work on inventing, hire somebody who's pretty good, and we'll give them some leeway, right? And so that's right, so that's kind of one pushback on this in a sense. Now, right, so what can we do here about that? One study I did, I don't think I've published this study in any way yet, but earlier, so I basically wrote a little a script that looked at every issued patent from the past couple of years, and so it went through and it looked at all the words in the issued patent, and then it also looked at all of the words in the original filed claim. So the words in the issued claims and the words in the original filed claims. And throughout kind of the generic words like A and V and said, and just looked at what might be called more important words. And most patents that were issued include words in the issued patent that were never in the original claim. And a substantial number, something like 40%, include new words in this issued patent that were never even in the original patent application.
so the
Okay.
spec, nowhere even in the spec.
Right, nowhere even in the specification. Now, right, and under U.S. law, that is allowable if there was sufficient disclosure in order to show that, right? And just what's the problem with that? The problem is when you draft your patent application, you take time to think about how am I going to draft these? What are the elements of the claim? Oh, I need to disclose those, and so you write in your disclosure in this, right? You describe what each of those claim terms are, but then when after the fact you add this in, right? There's no definition, or even loose definition for what that means, and so that directly leads to ambiguity, right? So what's this? Yes, Kevin.
Unless the examiner says, I don't understand this.
Right.
And in your prosecution history, you say, oh, when I said that, I meant this. And especially if that is a more specific definition, you're stuck with that. So, in fact, even though it's less ambiguous, paradoxically, because you've actually taken a position in prosecution that you're going to be stuck with, that may make your claims not be able to do what we were talking about a minute ago, reach out and get the future. Which I think is why, I would say ambiguous, I would say not straightforward. and there's a reason, I make that distinction. And that is that you want to be able to say that the language you use does reach out for these things that you couldn't expressly say. But there's definitely a line, if you get beyond the penumbra, you get into insolubly ambiguous territory. And although it takes a lot to get there, I think that runs a bigger risk.
Right, and I'm on board with Kevin's ideal that I think that I don't think the solution has to be that every word that you said in your original application is exactly in the issued patent, but there needs to be a process by which when you are drafting your claims and amending your claims, that there goes through a process that at least in our current system would be vetted by patent examiners to ensure that these claims that the claim terms are not subject to a wide variety of ambiguity.
But that shouldn't be, Europe is like that. I mean,
Well, right. So other countries do have strict, right.
So-
And I don't think we have to go there, but we could go there, and we would deal with it.
I actually have a question, rather than a comment. The question is, Judge Rader and Chief Judge Rader and Judge Lori seem to be having a little bit of a debate these days. And Judge Rader is the claims define the invention. The name of the game is the claim. Judge Rich said it, therefore it has to be true. And when you read his decisions, he very much depends solely on the claim terms. Judge Lori seems to be taking the position that your invention is what you say it is in the spec. And just the question is, which one of those philosophies do you think is more transparent? Is the way you would get to the more transparent patent system?
Yeah. Do I have to answer that? Well, right. So my first response would be that it would be nice if we could pick one. Right, and so that, and that's the usual response of business folks is to say, tell us the rule. We know how to make money once we have the rule out there. But if it's so ambiguous that we don't even know the rule, we can't follow it. And so the first response is to pick one. Now, if we think in terms of, we have this kind of interesting disconnect, and Kevin, you and I have talked about this a little before, between an individual patent, and patent prosecutors are prosecuting individual patents, and litigators are litigating individual patents. But then companies are holding these portfolios of thousands and tens of thousands of patents in these massive portfolios, and there's kind of these portfolio manager professionals that are totally different from the folks who are looking at the individual patent, and we have these kind of two levels of perception, and there's not a lot of connection between them. And so I think it would be beneficial for kind of our system, if we want this to be a coherent system, to have rules at this minute level that help connect and interoperate at the bigger level.
We can blame the patent office for that.
Yes.
For the restriction practice. Really, when I first started practice, I might have gotten 1 or 2 restriction requirements. And then as the practice got more mature, I got one that had 132-way restriction requirement. What does that require? 132 applications if I want to get all the claims. And usually, the application was filed with the whole device in mind, for example. And so that squarely is on the patent office from my point of view.
Well, that's right.
Yeah, I was going to say.
Okay.
I want to see it, and this. I don't want to discriminate on only do that side of the room.
Right.
In regard to possible solutions for some of these problems, for encouraging assignments, take a page from the copyright law and say, for example, you can certainly sue whether the assignment is recorded or not, but if you want, say, treble damages, then it has to already, you can't do treble damages for anything that occurred, if it actually occurred before the assignment was recorded. So that same kind of incentive rather than requirement. And which as far as I can tell, seems to work pretty well for copyright. And anything that's very variable gets recorded as a matter of course, because that opens up statutory damages.
And copyright isn't quite that way, though. You just have to record the copyright, and not necessarily, and the ownership. Right. So you don't have to continually update the ownership.
But still, that incentive structure rather than requirement seems to work pretty well. More people really want statutory.
That's right, and that works in real property as well.
Yeah. And then as far as the complexity of claims and the ambiguity of claims, or patents anyway, I think if the number of claims if it was a lot more expensive to have very many claims at all, that the reaction would be to have much more narrow picture type claims as the 1 or 2 claims you get cheaply. As it is, if you get 20 for this, price of 1. I think the reaction is, well, sure, why not? Why not go as broad as possible, even though we probably can only defensively get away with suing on 1 or 2 of the narrowest ones. Why not try for it? But if it was very expensive to get 20, if it was, if your fee got you 1 or 2 or 3, I think the reaction would be to go narrow.
right, I mean, so outsiders to the patent field hear things like, what you need, right, you've had one invention, and you need 20 different ways to restate this one invention before you think you've actually covered the invention. Right, for those of us who have practiced in patent law, we know that's the way we do it. But for outsiders, that's ridiculous. That's like when you buy a home, right, and you would just restate what you've bought 20 different times, right? Maybe by doing meets and bounds, maybe you have a plat down, maybe you also then take photographs of it, and then maybe you also describe, right? You have somebody describe the photograph, and you just do it time, right? And that just leads to confusion. And
but if you're property right dependent on what you whether you see the boundaries, you may have to describe it by the global view on a foggy day, on a clear day when it was hailing. I mean, we benefit in real property that we can draw a line.
Right.
You need to do it with GPS now. You can actually draw. It's harder to do for intellectual property because you're taking a thing and you're describing it in words, and that's not very efficient.
Or a thing you can't see.
Back to the
Right, or a molecule, right? Well, yeah. But the problem with that is then, if you make a working model of your molecule, what you really can see is the NMR spectra. If you never actually see the molecule.
Okay, you have 1, 2.
I want to actually go back to Bernard.
So let's talk about Bernard.
sorry, it's not my fault.
I thought you did an excellent job of sort of laying out the issue. We heard one solution, call a judge in Wisconsin. And maybe that's all it takes, but just, letting judges know what the effects are of what they're doing, but solutions, I mean, what do you see as sort of the next steps? And
Yes, I mean, that's something I have been thinking about, although I don't think I have anything ironclad. So one clearly is actually surprisingly just educating the judges, because my sense is every time I've talked to a judge, no one has actually disagreed that it's a problem. So that it seems like they just think, oh, I think it's really sort of the last thing that they're dealing with on in a huge case. It's like, okay, I got a consent in motion. This is
Just publish the judge's names and patent.
but I think that will only get you so far because I think the truth is it's still a pretty large task if litigants abuse the system, right? I mean, if you're going to file 100 applications to seal, there's only so much a judge can do. They're going to take a look. They'll take care of the worst cases, like no, you can't file under seal case names. Which actually, and I'm not making that up. That's actually in a federal circuit decision sanctioning a party for among other things, making sure the case names are all redacted. I mean, the cases they're citing to, right, precedent. And so I feel like the next step then is to actually do something and provide some disincentive for the litigants. Now, that could actually be sanctions. I've been playing with the idea of sort of this modified sanction where you get so many tries and you keep on, but you lose your tries, and at some point it's sort of like what you do with your kids. You say, no, you can't do that. No, you can't do it. No, you can't do that, and that's going to cost you your dessert. That kind of thing. But I think that if parties, litigators are persistently filing these things, then I think we have to be a little sterner. But I think the first step is just making sure everyone understands this really is the rule. Right?
Bernard, are you concerned about the legitimate trade secret rights of the parties?
I am not as concerned as the Federal Circuit is concerned. So just let me give you the big picture. We have to talk a little bit. Why are the parties, sealing this information? So obviously it's very clear they're sealing too much information. No one would dispute that. No one would say, oh yeah, you need to, they should not cite the Markman in public. No one would say that, right? We all know what Markman is. So that came through, right? So the question is, well, how far do we go, right? And so in the Apple Samsung case, that was the case where the judge actually went the other way, actually even further than I think I might have expected, where she said profit margins. No, that's not public. That is not sensitive information. And it's pretty clear under the existing law that actually just because it's a trade secret doesn't mean it satisfies the test for filing something under seal. Actually, the case law is a little fractured, but For pleadings that are like summary judgment motion pleadings, it's pretty clear. You have to have a compelling interest that is above and beyond necessarily it being a trade secret, which has value for being secret. But you need a compelling interest to hide from the public. And I actually think that what really happens is that if you're an attorney representing a company, I don't think the partner is deciding whether something should be sealed or not. I think a junior associate is, and I think the junior associate only gets in trouble if they sealed something, they didn't seal something that should have been sealed. They never get in trouble for trying to seal something that shouldn't have been sealed, right? And so that creates a very odd dynamic. But I think that there is sort of this level of paranoia that goes on up. I think same with the partner, I'm not going to get in trouble. And I think the in-house counsel, I'm not going to get in trouble. And so that we get this sort of culture of sealing everything. And I think actually far less would actually hurt people than the companies if the things were sealed. And so in this Apple Samsung case, Judge Chao refused to seal profit margins. And the argument that Apple and Samsung made was essentially, well, gee, our competitors and our suppliers are going to negotiate a better deal if they know our profit margins. I actually have been in negotiations with large companies like Apple previously when I was representing, and I can tell you, we never talked about their profit margins. We know you're making so much money, Apple. I'm not going to sell you my chips unless you pay more. I mean, that just didn't happen. I mean, it was sort of like, no, we're Apple. We're paying you. You know, we can go to so and so. I mean, that just and we, take it or leave it. I mean, that's so. I mean, I thought that argument shouldn't have been accepted. But the Federal Circuit did buy that. So I'm not as sensitive to most of those things.
And it's interesting because when I do a lot of mediations, and obviously when I'm caucusing with one side, we promise confidentiality. So I hear all the time, don't tell the other side this, but, and it's important information that I think would actually help resolve the dispute. And so my question is, why not?
Yeah.
And basically walk them through what is so important about this. You think it shouldn't be the other side. And more often than not, they go, you know what, maybe we should share that. And it seems to be kind of the same.
Yeah, I think
if the parties want to take the effort and time to take that extra step.
I think if attorneys actually sat down and really thought seriously about what should be secret, they would find that much less of what they think is secret really would be harmful if it was disclosed.
Okay. Gentlemen?
So I wanted to maybe follow up on this cultural practices issue and secrecy. And from the inventor standpoint, is anyone reasonably justified anymore in the wake of modern technology believing anything will be kept secret? And if there is anything that can otherwise gain protection by filing intellectual property registration rights, they should be advised to do so, elsewise be sued in malpractice.
Who wants
And
to?
Edward Snowden, NSA,
I mean,
this-
just last year here in Missouri, we put a couple of people in prison for trying to. So there are two Chinese nationals who had come to the U.S. To try to get into a Corning plant because Corning had been making a certain type of glass at this plant for the last 50 years. And they wanted to see exactly how the factory floor operated. And so they put an ad in Craigslist that they wanted to hire away an employee and they would pay a substantial sum. And the FBI set up a sting and then prosecuted under Missouri, I think under Missouri trade secret law. And so in that sense, there's folks willing to pay in that sense, hundreds of thousands of dollars to get at that information, and so I think today there are still valuable trade secrets.
But if I can just follow on to one thing, do you really believe that information isn't, once it's in form, finding its way into other markets? And if you want to have any protections, you really do need to file, but you have to go back to the transparency that registry rights really provides. And trying to hide the secrets. I mean, it is so easy to discern business intelligence now by other means, by electronically deciphering. We're on the verge of solving the P versus NP problem, I suspect. And once that happens, everything is not going to be a secret that is in digital form. In which case, are we at that sort of cultural crossroads? You better use the registration rights you have else you really are gonna seriously risk not being gamed out.
Yeah, I think that it's legitimate that information flows faster today than it ever has before, and all expectations are that it will flow even faster in the future. And so if you have rights that are in that information, or right, if you're making money from that information, you better find out how to protect it, and that's what intellectual property serves. And maybe it fits very neatly into this modern world because it is a way to allow the information to flow, but still send some value back to the originator of that information.
You had a question for
Oh, Bernard, I had a question. So here at Mizzou, we have these plans to start up a form of a clinic for our students that's going to focus to some extent on intellectual property issues. What do you think of the feasibility of having part of that being that the students, that we intervene in patent case after patent case as a third party, asking them to unseal records?
Well, I'd love it.
I mean, is it like,
is it feasible?
Right.
Oh, is it feasible? I mean, the feasibility is probably just a travel issue, right? Because I think most of the cases are probably not going to be all litigated in a court right by you.
Right.
The documentation to prepare the motion for the press is actually fairly minimal. I mean, and I think it's fairly similar each time.
Mm-hmm.
So I think that the challenge will be getting someone
local counsel essentially to.
Yeah, I mean, so actually, I think you have a little bit geographic getting a local counsel, but actually that's easy. So I mean, as soon as I started putting things in your blog, I got attorneys from all over the country saying, I'll do this for free. That's why I volunteered to the press. I said, I can find someone who will do it for free. It's very clear that attorneys this is the kind of pro bono work that I think, for some reason, sort of rings a bell and people want to do. You actually have to have so I did talk to some of my federal courts colleagues about this. So they said I actually didn't have standing as a professor likely, but that the press was the ideal standing. So you have to get someone in the press that is willing to take this.
Would a student newspaper count?
So the question. So what I didn't go
Or a
is
blogger.
Student newspapers or bloggers. I didn't go there, and so but I think there's at least a reason to think that they would count. And it sounds like this would be very welcomed by the courts themselves.
George?
Yeah, so this is actually interesting and a little bit surprising. I wasn't aware of the level of non-disclosure. So, in my practice, back in the heyday of technology companies, I did a lot of IPOs and securities work. And as you know, when you do a public offering for a company, you have to file all the material contract with the SEC. Those become public, and you can file confidentiality requests to go along with those. But under SEC rules, as they've developed today, you can only delete individual words and phrases, very limited, and you have to prepare a memo and argue with the SEC about every single one of those. And the standard is very high.
Right.
And it strikes me that the standard is different here, right? Because the SEC does acknowledge that there's a public interest, obviously, that investors' interest in knowing the information. And I'm just curious why the standard would be so different. Have you thought about it?
So actually the legal standard in the cases where it's fought out is high. It is actually a very high standard. But if you actually go into and look at these applications still, they're not trying to meet them. So I just want to be absolute. There is no, if you look at the application to seal, it says, this is a compelling interest, I have my declaration of so-and-so. I mean, so-and-so that said, no, I mean, most of the cases, the application seal is one page. One time, usually a paragraph saying, this is a secret and has been designated a secret. And then you don't, the issue, the order is a minute entry order saying granted, pro forma. So, I mean, there's no, so in the cases where which is, I would say, 95% of the cases, there is not this sort of conscious thing. There's not a conscious application of the actual legal standard. Now, if you look at the Apple Samsung case where the Judge Coe said, hey, I'm actually going to apply this rigorously. Well, then they actually filed declarations. You have to see these huge briefs, 30-page orders, analyzing these briefs, and the actual standards are being held. But most of the time, you actually get pro forma acknowledgement. And in fact, in the Eastern District of Texas, the local rule is you don't have to file an application. You just have to, a declaration by the attorney, this should be filed under seal. Unless it's changed in the last year.
Mine is just more of a comment on this. Under IPRs, the PTAB, the DTAB is showing that you have to file a motion to seal and you have to have reason for good cause, and they're being pretty strict on that analysis. And without going into comments about clients, I know that amongst the patent bar, there's kind of this consideration of, all right, do we really need to put that information in to establish our case? Because the PTAB is being very strict on motion to seals,
Yeah,
whatever it's worth.
so in the Apple Samsung case, the parties actually stipulated to a lot of, it looks like the parties actually stipulated to a lot of things that they weren't actually going to put into evidence, so to avoid this problem, right? So that both sides had this problem, they didn't want certain information. So they actually decided, well, we're not going to provide this kind of information and we'll make some agreements about that. So there was something about like that going on there as well.
We have time for about 2 more questions.
Has abuse of, or what might be called abuse of orders to have to be sealed, has that ever been used as a basis for making a case exceptional for damages?
I'm unaware of it. The most I've seen is there's a case about 3 years ago in the federal circuit that just sanctioned a party for sealing too much. It was really a minimal slap on the hand. I think it was just a signal, hey, don't do this.
Okay, do you guys want any last word? Oh, one more question and then last words.
Did you say that when you went back to the manufacturing companies that they were being sued for use of property in research?
That's correct.
Is there a way we can go back to a research exception? Because we've been talking about incremental improvement. How the hell do you do that unless you can actually work with the itself, or to know that it doesn't work in the first place?
So this is a sort of different kind of problem because really all the damages were flowing from actual sales in the United States. So what they did is they connected. So what was going on, semiconductor chips were being developed in labs, primarily say in Silicon Valley, but they're actually being manufactured overseas, perhaps China, sold overseas, put in product computers overseas, so that the U.S. chip manufacturers actually never touched real product. They just had labs, right, and marketing organizations. They get sued for use in the United States from the labs, but they would never have been sued for just that unless there were substantial U.S. importation later of the product by a third party. And in fact, that's what the damages theory is based on. So there's a disconnect between the actual infringing, the predicate infringing activity and the damages theory. And that's what...
Was an inducement to infringe?
The inducement was also out there, but they were also being sued for direct infringement. Yeah. But the inducement has the added problem that they have to have knowledge of the patent. But if you go to direct infringement, you can go straight from the beginning, right?
Okay, any last words?
Okay.
So we've got a couple of minutes. I just wanted to make a couple of closing remarks and thank all of you for coming today. First of all, I think it's been a really great day. Jim Levin and I Jim didn't have anyone introduce him, but Jim is our right. So Jim is a law professor here at the university at the law school. He also runs our mediation clinic and has been a professional mediator for the past 2 decades and has basically mediated all types of case, almost any type of case you can imagine. He's done it, and he also now takes our students through that process and gets cases from both federal court and state court and walks through that. A year ago or so, Jim and I were talking about, and he had done some intellectual property cases about the idea of us co-mediating patent cases, and so this conference kind of emerged out of that about that discussion and that work, and so thank you, Jim, for being here and organizing that and teaching me so much about this process. I've been really impressed with the level of discussion today, both by the speakers and by the entire audience, and thank you for that. In a few minutes, and in fact, right immediately following this, the process is that we're going to, for anyone who wants to go, everyone's welcome to walk across the green that's just outside the law school to the Alumni Center, where we're going to have some drinks and hors d'oeuvres and more than informal conversation. So.
And I too want to thank you for your participation, both our panel and from the people who traveled from all over to be here. I think this has been a fascinating, interesting day. And I'm someone who's sort of on the outside of the patent world, but I've learned quite a bit today, and I hope you have too. As I mentioned this morning, the panel members are going to be submitting written papers that we will put in our Journal of Dispute Resolution, which is scheduled to come out in the spring. See Rachel Hirschberg back here. She's our editor-in-chief. And do you want to just, if someone wants to get a copy of that, or obviously online, but anything you want to add about the symposium issue?
Once the spring edition is published, which will be late next spring, you can go to the Journal of Resolution webpage, and then you receive the to a law website, and there's information there about how to either subscribe or order a single copy. But that's something that very, very easy to do. It's pretty much all that we can do.
Anything else?
Great. No.
Thank you, and we
Thanks so
really,
much.
really hope to see you. It's just the building to the west of here for the reception, and thank you very much.